Morning and welcome to the November 16th Victim Compensation Board meeting. For those of you in the room that are appearing on a specific agenda item or wish to offer public comment, the microphones at the podium and tables are directional and require that you hold them fairly close to your mouth when speaking to ensure your testimony is captured by our audio equipment. For members and participants who are appearing via Zoom, if you cannot hear the presenter, please use the comment feature to note that, as staff are monitoring the comments in real time. Council, please call the roll.
Member Becton.
Present.
Johnson.
Here.
Chair Ravel.
Present.
Good morning, everyone. Item 1 is the approval of the minutes for the September 14th, 2023 board meeting.
Are there any discussions, additions, or corrections to the minutes from board members?
Chair, I did have one comment, and this is relevant to your speaking into the microphone comment. At the last meeting during the executive director's report, when we were talking about the annual report, I had made a comment about looking backward, having data that sort of looks backward and compares the efficacy of the programs year on year. And I think I was speaking at an angle. So I went back and looked at the video and it was hard to hear my comment, but I didn't see that reflected in the notes, and I was hoping we could have that added back in.
Thank you, Member Johnson. And request to staff to add that item into the minutes.
Okay.
Thank you.
With that addition, do I have a motion to approve item 1?
I'll move to approve item 1, the minutes.
I'll second. Council, please call the roll.
Do we have any?
Excuse me, public comment.
Thank you.
Is there any public comment on this item? Seeing none.
Council, now you can call the roll.
Thank you. Motion before the board is approval of the September 14th, 2023 minutes as amended, as just noted. Member Becton.
Aye.
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you. Item 2 is a public comment. This is the opportunity for the public to comment on items that are not on the agenda. As any items discussed during public comment have not been agendized, the board is not permitted to take any action on these matters at this meeting. Please note, if you wish to offer public comment regarding items 6 through 9, there will be a separate call for public comment when each item is heard by the board. For those on the phone, if you previously indicated your desire to offer comments during this meeting, we will be calling on you by name or phone number. For those participating via Zoom, please raise your hand if you wish to offer comment, and we will acknowledge you and let you know when it is your turn to speak. I see we have Margaret Petros. If you can, please go ahead.
Thank you. Good morning, Mr. Chairman, board members. Margaret Petros, Executive Director with Mothers Against Murder, a nonprofit victim advocacy group. I am here to bring your attention to a request for a system upgrade to trigger staff to process when to process support loss. Support loss mostly impacts families of murdered victims, children, spouses whose member had died and lost income. Recently, I asked under the Public Records Act, how do staff know what is the policy to process a future support loss? Because I have cases where the first time it's processed and then nothing happens. And the answer back said there is no such policy. No public records indicates how do staff know. I have a case that's been 7 years. A professor was killed. His wife and children are left without a support loss. Initially, there was life insurance, so the file was processed as fully reimbursed. But I really can tell you there has to be hundreds, if not thousands, of families out there that are not getting their support loss. No victim should have to alert the board. So many don't even know they're eligible, that just wait and don't hear back. So please look into it, and I wish you would report back on it maybe at a later date. Thank you.
Thank you for your comment, Ms. Petros. And we would like to follow up with staff on that item to get a briefing on that if possible. Thank you for raising that.
Thank you.
I don't see any other comment. We will now move to item 3, which is the executive officer's statement, which will be presented by Executive Officer Linda Gledhill.
Morning. A few items to share with the board. The last few weeks, I've had the opportunity to visit several places to see the work of CalVCB in action. About a month ago, I traveled to Monterey Park in Los Angeles with GovUp Secretary Ton to meet with local community leaders and visit the resiliency center that's been set up in the wake of the mass violence events that occurred last January during the Lunar New Year celebrations. It's a place where everyone knows someone who was impacted by that event. And it was heartening to see the work the community is doing to support each other as they heal together. At CalVCB, we've received 64 applications from that event. We know there are more eligible victims. I'm sure some of you saw LA Times story this week talking about that. We continue to reach out to advocates and community leaders to make sure there's awareness about our services. We're also working on increasing our outreach as we approach the 1-year anniversary of the shooting. Also, a few weeks ago, I traveled to Napa for the opening of the Northern California Regional Trauma Recovery Center being run by SANE START, which stands for the Sexual Assault Nurse Examiner Sexual Assault Response Team. This facility was made possible by the $2.5 million pilot program grant that was approved by the legislature and by this board. At that grand opening, I was able to tour the facilities to see how they have established different spaces for children, teens, and adults to all feel comfortable as they talk about the trauma that they have endured. I was also able to meet with the staff, and it's very clear they are dedicated to helping those seeking support. It was an exciting opportunity to see our TRC dollars coming to life and expanding services in local communities. Also last month, CalVCB held its first regional conference since the pandemic in partnership with the McGeorge School of Law Victim Resource Center. This event brought together more than 80 advocates and community partners from throughout Northern California for a full day of information about victim services. We had panels discussing reaching underserved victims, human trafficking, federal funding, and how state agencies work together to serve victims. In recognition of October being Domestic Violence Awareness Month, our keynote speaker, Dr. Maura Orby from the California Partnership to End Domestic Violence, highlighted the importance of collaboration and self-care for individuals in our line of work. Regional conference was a great success, and we provided people an opportunity to interact, network, and learn about emerging ideas. It's been refreshing to be able to attend these events, and we're planning more for the coming year. I want to update the board members about our upcoming Trauma Recovery Center grant cycle. CalVCB will be posting a new Notice of Funds Available, or NOFA, for the Net Cycle Awards sometime in December. The NOFA includes information about the timeline for applying, the application requirements, the submission and review procedures, budget requirements, and more. As you know, the TRC grant application process is competitive. Each year, there's a finite amount of funding available to grant to TRC applicants, and CalVCB cannot predict how many organizations will apply for funding. There's also no statutory or other limits as to the amount of funding that may be requested by applicants, and there's no baseline funding, and no TRC applicant is guaranteed funding. Existing TRCs who are interested in continuing their programs must reapply. Because funding is not guaranteed, CalVCB encourages TRCs to diversify their funding when possible. The NOFA requires applicants to respond to 6 narrative questions that mirror the requirements for TRCs set out in state law. For example, we ask the applicants provide examples of their organization's ability to provide outreach to crime victims who typically are unable to access traditional services. Applicants' responses to these questions allow a panel of CalVCB managers familiar with victim services and needs to evaluate each applicant's ability to meet the statutory requirements. CalVCB also considers crime rates and the geographical distribution of TRCs to ensure TRC services are available in underserved areas of the state. CalVCB also considers crime rates and the geographical distribution of TRCs to ensure TRC services are available in underserved areas of the state. CalVCB also considers crime rates and the geographical distribution of TRCs to ensure TRC services are available in underserved areas of the state. The NOFA provides applicants with detailed information to understand how their application will be reviewed and scored to make the process as transparent as possible. In response to feedback from the TRCs, we plan to add some additional clarifying language this year. Potential applicants will also have the opportunity to submit questions to CalVCB, and CalVCB will publicly respond to those questions so that all applicants have access to the information. Applications will be due in January, and we anticipate bringing tentative award information to the board at the March meeting. Finally, at the last board meeting, you approved us moving forward with proposed regulations. The public comment period for those regulations ended on Monday, November 13th. To solicit public comments, CalVCB shared the proposed regulation information with more than 11,000 partners, stakeholders, and providers, and posted information about the regulations on our website. We received several public comments during the comment period, and staff are in the process of reviewing to determine if any modifications are necessary in response to the comments. Additionally, in response to a request from a member of the public, we're planning a public hearing in early December. We plan to bring back the regulatory package before the board in early 2024. Lastly, the forced or involuntary sterilization compensation program ends at the end of the year on December 31st. Because December 31st is a Sunday and January 1st is a holiday, we will accept applications postmarked on January 2nd. We are continuing to do everything we can to encourage anyone who believes they are eligible for compensation to apply before the deadline. Since we began receiving applications in January 2022, we have approved more than 100 individuals for compensation. Additionally, we have started the process of sending the second and final check of $20,000 to the approved survivors. That concludes my remarks, and happy to answer any questions.
Thank you, Officer Gledhill. Really good to hear about the work you're doing in outreach in Monterey Park, and I hope that you're able to reach all the people who are impacted by that horrible event, and that they can get the compensation they're entitled to. It's also really good to hear about the new Napa TRC and the changes you're making to the process. It's always it's a really important program, and so it's good that you're making the process as transparent and as fair as possible. Are there any questions or comments from board members? All right.
Seeing none, we'll move to item 4, which is the legislative update, which will be presented by Deputy Executive Officer Katie Gardinas.
Good morning. The legislature is currently on recess and will reconvene on January 3rd. At the September meeting, I reported that 4 key bills were headed to the governor's desk. All 4 of those bills were signed by the governor. AB 56 by Assemblymember Lackey expands eligibility for compensation by CalVCB to include solely emotional injuries from certain felony violations. AB 1187 by Assemblymember Quirk Silva authorizes CalVCB to reimburse services provided by child life specialists. SB 78 by Senator Glazer specifies when a court shall issue a finding that a claimant is entitled to approval of a claim for compensation under Penal Code Section 4900. And finally, SB 544 by Senator Laird amends the Bagley-Keene Open Meeting Act to remove certain teleconference requirements and requires at least 1 member to be physically present at every board meeting. These bills all take effect on January 1st. Those are the highlights, and I'm happy to answer any questions.
Thank you, Deputy Cardenas. I had a somewhat different understanding of 544, but I don't think it's going to necessarily impact us, since Member Johnson and I are here in town, so it's easy enough for us to come by. But we'll see how it goes for the 2 years before it sunsets. Are there any questions or comments from the board on the legislative update? Thank you, Deputy Cardenas.
Is there any public comment on this item? Seeing none, we will move to item 5, which is a contract update, and it will be presented by Deputy Executive Officer Sean Ramirez.
Good morning, board members. For today's contract update, it is all informational. We are not requesting any approvals at this time. However, I'm happy to answer any questions.
Are there any questions or comments from the board on our contract?
Is there any public comment on this item? Seeing none.
Trustee Ramirez.
Thank you. Moving to item 6 is the proposed board meeting dates for calendar year 2024, which will be presented by Executive Officer Linda Gledhill.
Thank you. Consistent with its practices over the last 2 years, staff recommends the board meet every other month in 2024. We recognize that there may be occasions or circumstances where that might warrant a meeting outside the proposed schedule. If there's a specific claim or a erroneously convicted person claim finding of factual innocence that requires action within 30 days. For situations such as these, the boards would schedule an additional meeting with 10 days notice. However, we present to you in your binder the standard board dates and ask for your approval.
Thank you, Officer Gledhill. Is there any discussion from the board regarding the board meeting dates for calendar year 2024 from board members?
Good morning. This is Dinah Beckton. Just to mention that I have a conflict that would prevent me from attending the meeting on the 18th, I believe is the proposed meeting date of January. And I would make the request that we, if possible, and it meets the other board members' schedules, to meet on January 11th.
It's certainly fine with me.
So how about we, if possible, give all the members a chance to review their calendar, and if we could approve the calendar with the note that we will potentially move the January meeting either up or back a week, depending on everyone's schedule, if that is all right.
That works.
Okay, do I have a motion to approve item 6 with the caveat that we may be moving the January 18th meeting?
I move to adopt the board meeting dates as proposed for calendar year 2024 with the caveat that there might be a change in the January 2024 meeting date.
I second.
Is there a public comment on this item? Okay, seeing none. Council, will you please call the roll?
Motion for consideration by the board is adoption of the board meeting dates as proposed for calendar year 2024, with the noted exception of a possible change to the January 2024 date. Member Beckton,
Aye.
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you. Item 7 is the Penal Code Section 4900 claim of Sean Martin, which will be presented by Chief Counsel Kim Gutierrez.
Sean Martin filed an application as an erroneously convicted felon with the CalVCB on September 14th, 2021. That application is based on his 2017 convictions for murder and shooting at an occupied vehicle, which were reversed on direct appeal for instructional error. The claim seeks $358,820 for 2,563 days of imprisonment. The Attorney General objected to the claim, arguing the evidence fails to prove Mr. Martin's innocence by a preponderance. As explained in detail in the proposed decision, the claim is recommended for denial, as Mr. Martin has failed to meet his burden of proof, showing by a preponderance of the evidence that he is innocent of the challenged convictions as required by Penal Code Section 4900A. Mr. Martin represented himself throughout these proceedings and today is also represented by Tina Flores. The Office of the Attorney General is represented by Deputy Attorney General Catherine Althizer.
Thank you, Counsel. We will hear first from Mr. Martin's representative, Ms. Flores.
Thank you. I want to open up with the Ames claim of $20,000, and this was removed from his account when he was in Santa Rita. And he had called numerous times to ask about what happened to the 20,000, and he got no response. And since his career path as a sprinkler fitter has been reduced to nothing, he has been unable to return to his union job. And at the time of his incarceration, the amount was $52.59 per hour, and now it's $70.55. The conclusion is a probate case regarding a family member. He received $11,631.43 payable to CalVictim Compensation Board against Sean Martin. Mr. Martin was found not guilty. And so I feel that he is entitled to his all of his reimbursements. The AG, you stated earlier, the AG found him guilty and not qualifying for reimbursement, but the jury had found him not guilty. So with that, I end, and I'm going to play Mr. Martin's recorded message. I don't know what's wrong. It was here a minute ago and it's gone.
All right. Take your time. Is this the item that we have the transcript of as well?
Yes, yes, you do.
Okay.
Word by word.
Got it. Well, if you let us know if you're still having trouble accessing it, if it's all right to move on to Ms. Altizer's presentation, and then we can come back to you if you've been able to find the recording, if that's all right.
Thank
Okay,
you.
thank you. All right, Ms. Altizer from the Attorney General's office, we will hear from you next.
Good morning, Catherine Altizer on behalf of the Attorney General. The Attorney General agrees with the hearing officer's proposed decision. And unless the board has any questions, we ask that you accept the proposed decision.
Thank you, Counsel. Ms. Flores, have you been able to get the recording?
It was here earlier and now it seems to be gone.
See.
I have done nothing to change it, but it seems to be gone.
I'm sorry about that. Technical difficulties. We do have the transcript, and I was able to take a look before the meeting. If it's all right, we can move on to discussion of this item by the board. Any items from the board? Yes, Member Becton.
Thank you, Chair. I had a question, and I wanted to get some clarification about how or if the jury's acquittal played into the burden of proof. I understand that the burden here is more likely than not, more likely innocent, excuse me, than guilty. And there's a list of things that were considered that would lead to the guilt. And then there's a mention of the things that might lead to Mr. Martin meeting his burden. But one of them being his claim of self-defense, although there's statements that it was inconsistent and evasive, but also the other one being the jury's verdict of acquittal. And I just have some difficulty because there's really not much else said about that acquittal and what we should be doing with it in this setting, with the burden, really being more likely innocent than guilty. And we have this system where 12 people from his community heard all of the evidence in the case and deliberated and returned a verdict. and of acquittal. And so I'm having trouble with how that acquittal with 12 people from the community making that decision is supposed to factor in to our decision today in terms of him meeting his burden, because the brief really doesn't say very much about that at all.
Council, do you have any thoughts about that?
I would suggest that we hear from the Office of the Attorney General on this issue.
If I could say something, I have the video now.
Oh, yes, of course, Ms. Flores. If you'd like to present the video, we can do that, and
Thank
then we
you.
can hear from Ms. Altizer.
Okay, okay.
Want to open and basically close with this point of view. William Petoskey, Virginia Martinez, and Joanna Casillas clearly states in there that they themselves threatened me personally, or Melissa Martinez herself threatened me. Nowhere in transcript, previous arrest records, or conviction paperwork that states I have before or at any time up to this point have a propensity for violence. So those comments or suggestions or statements spell out the line and type of deception the DA Ford and the court judge Horner tried to push over to the jury. Constant confusion and flat out lies or switching legal standpoints, meaning once we presented evidence of Melissa Martinez's propensity for violence, the DA took that over and used my self-defense, my specific claim of self-defense directly against me. Joanna Casillas and Melissa Martinez fought a lot, with Melissa initiating most, if not all, of their hands-on fighting. The propensity for violence was clearly evident with Melissa Martinez, but the AG claims that I was this person who had or have a propensity for violence and making unfounded claims of self-defense. So the AG read all transcripts, I'm guessing, and still happened to inject their own narrative of the situation, just as the DA did, or has done. Having clear exculpatory evidence, DA Ford decided to switch the more crucial bits of my case by making my defense an issue of Melissa Martinez's, not mine. As in section 5.50.1, DA Ford turned it on his head and reversed the defendant victim position, setting grounds for an easy overturn in the appellate court. The propensity for violence was clear and only referring to Melissa Martinez's life issues, period, not mine. I've never made any claims of self-defense. There is no evidence of me engaging in violence that could be offered prior to this case, founded or unfounded. Erroneously is how I lost my first case, my first trial. At retrial, nothing was brought up concerning the first trial. They started from scratch. With my new DA and court judge being on watch, they had to play fair. Due to unfair and unlawful legal practices by the Oakland DA's office, my public defender, Foxall, tried to recuse the Alameda County DA's office from my case because of the malfeasance running rampant through that office. Yet, lies were still told at retrial regularly. Circumstantial evidence of all kinds and all makings. The same, if not more evidence that didn't come out at the first trial. Also, at first trial, the jury asked questions of law and were misguided, misled, misinformed by the court judge and DA Ford. DA Ford lied intentionally about who had a right to self-defense, me or Martinez, intentionally putting us in opposing positions and confusing the jury with his erroneous idea of self-defense, and with no help from the court judge, Jeffrey Horner, setting the jury straight on an issue of law concerning facts on who was in what position and prior threats made by the victim, not the defendant. The unlawful act of possession of firearm is a secondary offense, not an outward, initial, or active crime. If I had a concealed weapon and no one threatens me with bodily harm or injury, then the crime of possession never occurs because no one becomes aware and nobody gets hurt. Self-defense is the ruling, if not by description, then by statute. Not guilty means justifiable homicide, not liable. The jury found me guilty only after being lied to by DA Ford because he had no other way to win with his lack of solid evidence. So he lied. Judge Jeffrey Horner failed his duty to give additional instructions to a very confused jury, leading to my erroneous conviction. Prior to my first trial, I was poisoned in Santa Rita jail 2 to 3 times. Once with something called H. pylori, an infection of the gut due to ingesting fecal matter. It was not intentional. The other 2 times were reoccurrences or something they could not identify. I had a pregnant woman, a girlfriend. By my 5th week in jail, she decided to abort because of these lies told to her. He's never coming home. He's in over his head. And Foxall, my public defender, even told these things to my family. Well, my sister, because everybody is getting up in age, has died during my incarceration, or lives out of state. So I had no one to call on. The state of California spent more than $70,000 per year to cage me against my will, against nature, and against the law for 7 years and 7 days. I am factually innocent of 1st and 2nd degree murder. I am factually innocent of all forms and degrees of manslaughter by way of jury trial, right? That's why I'm here on the outside, able to fight for my future. A jury of my peers, most, if not all, were not in my peer group. In fact, my peer group was not represented in either 1st or 2nd trial. Yet the 1st trial jury asked questions highly in my favor. But when those questions went unanswered by the court judge, it left the jury to think on its own about how to make the law and apply it as they see fit, which is why my 2nd trial went smoothly. Even with the new DA telling new lies, still the jury sided in my favor. With all of the evidence placed in front of them in a meticulously slow, one at a time, jury members would take the stand and be questioned individually while all others watched via television screening. So 12 plus 3 alternate jurors had a chance to hear each question asked at least 40 times or more. The jury had more than enough time to make a sound decision, and they did. Please don't put me in double jeopardy situation. Not guilty is the ruling. Please be fair and make this right. Thank you, Sean Martin.
Thank you, Ms. Flores.
Thank you.
Do either you or Mr. Martin have anything further?
I'm closing. I would like the board to take notice of the facts that he stressed. A jury of his peers evaluated a lot of evidence and found him not guilty. And doesn't that mean something in the name of justice? And as the system is titled Justice System, I ask that you please do what's right and let justice prevail. Thank you.
Thank you, Ms. Flores. Ms. Lighthizer, on that point, and going back to Member Beckton's questions about the impact of the acquittal and the burdens of proof that apply in the different proceedings, what is your response to that question?
First, I would note, as you just said, that there are different burdens of proof at a jury trial and before this board. And at a jury trial, it's a higher burden of proof, and it's incumbent upon the prosecutor to meet that burden of proof. Whereas here, the standard is preponderance of the evidence and it's claimant's burden. And is detailed on page 17 of the proposed decision. The hearing officer lays out the relevant considerations for this board to consider. And it notes that the reversal of the judgment of conviction is one of those considerations, but there are others. And notably, this board is not constricted to the record of conviction. The board may also consider any other information that it deems relevant to the issue, even if inadmissible under the traditional rules of evidence, so long as it is the sort of evidence on which reasonable persons are accustomed to rely in the conduct of serious affairs. So the acquittal is just one piece of the puzzle. And I think, as stated earlier, the proposed decision fairly balances and takes into consideration all of these factors.
Thank you, counsel. Is there any further discussion or questions from board members? Seeing none, do I have a motion on item 7?
I'll move to approve.
I'll second.
Is there any public comment on this item?
Seeing none, counsel, please call the roll.
Motion for approval is adoption of the hearing officer's proposed decision in the Penal Code Section 4900 matter of Sean Martin. Member Beckton.
No.
Member Johnson.
Yes.
Chair Ravel.
Aye.
Motion passes.
Thank you. Item 8 is the Penal Code Section Claim 4900 for Dupree Glass, which will be presented by Chief Counsel Kim Gutierrez.
Hello again. As you can see from your materials and also the materials posted on the website, the next 2 items are related PC 4900 claims. The first is Dupree Glass, which is based on an application filed on December 1st of 2020, which was initially stayed and then supplemented on April 24th of 2023. This application is based on Mr. Glass's 2004 convictions for 11 counts of attempted murder and 1 count of shooting at an inhabited dwelling. The attempted murder convictions were vacated by writ of habeas corpus and dismissed upon remand in 2020. and the conviction for shooting at an inhabited dwelling was vacated pursuant to Penal Code Section 1473.7 in 2023. As there was no objection to these claims filed by the Office of the Attorney General, compensation is automatic under Penal Code Section 4900B. Accordingly, the proposed decision recommends compensation in the amount of $859,040, which represents $140 per day for each of the 6,136 days Mr. Glass was wrongfully imprisoned. Throughout these proceedings, Mr. Glass has been represented by attorney Annie Deladonna. The Office of the Attorney General is represented by Deputy Attorney General Seth McCutcheon and also Jonathan Kraus.
Thank you, counsel. We will hear first from Ms. Deladonna, counsel for Mr. Glass.
Yes, thank you. I just want to thank the board and the chairman for their consideration of this claim. These two individuals, Dupree Glass and Juan Rayford, were wrongfully convicted and imprisoned for over 17 years for a crime they did not commit. It's been a long journey. It is a very momentous day today. After proving them factually innocent of the shooting in April 2020, we are very pleased to be here before the board, and we ask that the board approve their compensation. Thank you.
Thank you, counsel. Is Mr. Glass present, and would he like to address the board? I don't see him.
Yes, I'm present. I can't figure out how to get my video on.
Well, that's okay. We can hear you.
I just want to say thank you for hearing our case, and that's really about it. Thank you for hearing us out.
Thank you, Mr. Glass. We will hear next from Mr. McCutcheon from the Department of Justice.
Yes, good morning. We submit on the proposed decision.
Thank you, counsel. Is there any discussion on this item from the board? Do I have a motion on item 8?
I move to adopt the hearing officer's proposed decision in the Penal Code Section 4900 matter of Dupree Glass.
I second.
Is there any public comment on this item?
Seeing none, counsel, please call the roll.
The motion for approval is adoption of the hearing officer's proposed decision in the Penal Code Section 4900 matter of Dupree Glass. Member Becton.
Aye.
Member Johnson.
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you. Item 9 is the Penal Code Section 4900 claim of Juan Rayford, which will be presented by Chief Counsel Kim Gutierrez.
As previously mentioned, this is a companion case to the one that we just heard. It is similarly based on a December 1st, 2020 application with the same procedural history as just cited for Dupree Glass. The proposed decision recommends compensation in the amount of $859,040, which is based on $140 per day for each of the 6,136 days that Mr. Rayford was wrongfully imprisoned. Again, the Attorney General filed no objection to this claim. And Mr. Rayford is also represented by Annie Deladonna, and the Office of the Attorney General is represented by Deputy Attorney General Seth McCutcheon and Jonathan Kraus.
Thank you, counsel. Ms. Deladonna, we will hear from you first.
Thank you. And I have really no further comments other than what I mentioned about Dupree Glass, but I just want to acknowledge one thing. We would not be sitting here today on November 16, 2023, if not for the heroism and bravery of Juan Rayford, because he is the one who initially pushed me to take this case, stayed on top of the law, on the kill zone law, and was very instrumental in helping us overturn much of that law in the California Supreme Court. And I just want to acknowledge once again that he is an incredible human being, and I very proudly stand by both their sides as their attorney of record. Thank you.
Thank you, counsel. Mr. Rayford, would you like to address the board?
Yes, I'm happy that this day has came, and I'm very grateful. And it's a humbling feeling that me and Dupree, we're here, and we're going to get compensated for the time that we did in prison, and for something that we did not do. So I am very thankful for that, and I'm thankful that is happening today. That's it.
Thank you, Mr. Rayford. We'll hear next from Mr. McCutcheon from the Attorney General's office.
Thank you. The Attorney General submits on the proposed decision.
Thank you, counsel. Is there any discussion on this item from the board members? Do I have a motion on item 9?
I move to adopt the hearing officer's proposed decision in the Penal Code Section 4900 matter of Juan Rayford.
And I second.
Is there any public comment on this item?
Seeing none, council, please call the roll.
Motion for approval is adoption of the hearing officer's proposed decision in the Penal Code Section 4900 matter of Juan Rayford. Member Becton.
Aye.
Member Johnson.
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you, council. The board will now convene into closed session under Government Code Section 11126 sub E to discuss pending litigation, and under subdivision C3 to discuss numbers 1 through 85 of the Victim Compensation Program. Board is now reconvening into open session under Government Code Section 11126 sub C3. Do I have a motion for numbers 1 through 85 of the Victim Compensation Program?
I move approval of numbers 1 through 85 of the Victim Compensation Program.
I second.
Council, please call the roll.
The motion before the board is approval of numbers 1 through 85 of the Victim Compensation Program. Member Becton,
Aye.
Member Johnson,
Aye.
Chair Ravel.
Aye.
Motion passes.
Is there any other business that needs to come before the board today? Seeing and hearing none, do I have a motion to adjourn?
Move to adjourn.
Second.
Council, please call the roll.
Member Becton,
Aye.
Member Johnson,
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you. The next meeting is scheduled to occur in January 2024.
Thank you, everyone. Happy Thanksgiving.
Happy Thanksgiving.